My spouse is a nightmare to deal with. How should I handle custody in divorce? Hi, I'm Bill Farias, founder of Farias Family Law. We got this question last week. We get this question all the time. It's very common. You have a parent who is trying to do the right thing by the kids, and then you have the other parent who, either because of some mental health, substance abuse issues, personality issues, is just an absolute nightmare to deal with. And so, how do you approach this? Well, first of all, there is no one-size-fits-all solution to this. But what I can give you is some general principles that will help you effectively deal with this particular situation. First of all, you do not fight fire with fire. And what I mean by that is these circumstances typically involve a parent being difficult, being vindictive, being nasty. And what happens is, if you engage in that and you reciprocate, then you are hurting your children, right? The more strain and conflict there is between you and your spouse, the worse off your kids are. So although it has to be very, very unpleasant and difficult to deal with some of the messages, the comments that you get, you do not want to add fuel to the fire, because you're just sending this down the wrong path. And I know some of you might be saying, well, it's easy for you to say, you're not the one getting these messages, you're not the one dealing with this, and that's very true. And I'm sorry you're going through this, but I can tell you definitively that working in this industry for well over a decade and working as a social worker well before then, a couple of decades ago, and having a lot of exposure and experience in mental health, I can tell you that anytime that you add fuel to the fire under these circumstances, you are increasing the risk that your child is going to develop mental illness, emotional issues, behavioral issues. So just don't do it. That's the first thing, right? Is you have to take the high road. So what do you do if someone is this difficult? Well, what you have to do is you have to assess your circumstances to figure out what an appropriate plan is. And the way that you do that is you reach out to a reputable family law attorney. They'll be able to look at the history, the circumstances, and give you a decent idea of where this might fall in terms of a parenting plan. The difficulty people get into is when they come to an agreement before they talk to a lawyer. Because then what happens is, once you put something in motion, like a parenting plan, it is very difficult to reel that back in if it's not working out. And we see this mistake happen all the time, where parents are trying to do the right thing, they're trying to work things out on their own, and then it backfires, and then it's very difficult to reverse it. First of all, the other parent's not going to want to reverse it. And second of all, if you end up before a judge on a custody issue, they will be considering the parenting plan that's been in place. So in other words, when you come to an agreement, a decision on a parenting plan, and you roll it out, you are creating a precedent, for better or for worse. So before you do that, make sure you talk to an attorney to figure out whether that makes sense for your particular circumstances. So once you have that figured out, then it's going to be on the attorney working with you to figure out whether it's something that can be handled sort of informally and without a court order, or if you actually need a court order. In many cases, with parents who are very difficult, I advise getting a court order in place, because these are people who can be manipulative, they can be difficult, they are going to push the envelope, and many times it's not about the kids at all, it's about them, and it's about their ego, and it's about hurting you. So it's very dangerous to operate without a formal parenting plan under these circumstances, because a lot of times it's just going to result in a lot of frustration. So in a lot of these circumstances, we will file paperwork with the court to get in front of a judge for a motion hearing to put a formal parenting plan in place. Sometimes what we do in these circumstances where you have a very difficult parent on the other side is we recommend using a parenting app. And there are a number of them out there, but basically this is a method of communication between the parties. It works because everything is essentially on record, right? This will be available to the judge. If there is a disagreement, if there are problems, you communicate about anything related to the children on the app, and that tends to be effective. In some cases, it keeps the difficult person in check to some degree because they at the very least know that their comments are going to be scrutinized by a judge if they're out of line and an issue comes up. So we sometimes recommend that, and it's very, very important for you to politely and civilly stick to the parenting plan. Now, generally, the court and attorneys expect parties to have some degree of flexibility, right? It's healthy for the kids. If something comes up, let's say there's a birthday party or some kind of event where there's going to be a change in the parenting plan, or you want a change in the parenting plan, the other party may want a change in the parenting plan, then there should be some flexibility, but that should be the exception and not the rule. What you may find in working with a parent who's very difficult is, again, they are always pushing the boundaries. And so you have to be careful about getting yourself into a situation where you are agreeing, and then before you know it, you have a different parenting plan that doesn't really work for you, that doesn't work for your children. So you have to keep your eye on the ball. You have to stick to the plan that you come up with your attorney, and sometimes you have to politely decline. And again, you are communicating in a way that is civil, that is diplomatic, that is fostering the relationship between the children and the parent, as difficult as that might be, because it's what's best for the children in some circumstances. I'm going to set aside the cases where the parent having a relationship with the child is clearly not in the child's best interest. That's very rare. It does happen, but I'm going to set that aside for right now. The majority of cases fall in this bucket of, yes, the children should have parenting time with the other parent, but the relationship between the parents is toxic and in some cases abusive. And that doesn't necessarily mean that the parent shouldn't have any contact with the children. So those are the cases that we're talking about for purposes of this example. So in those circumstances, you're continuing to be civil, you're continuing to be diplomatic, but you are also keeping your eye on the ball, keeping in mind the goal that you and your attorney set, and sticking to that. So these are just some of the things that you can do to deal with a parent who is very difficult. If you have any other questions about this, you can call us 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, you can subscribe to our channel, share it with anyone you think might benefit from it, and you can find us on social at Farias Family Law. Thank you. Have a good day.